Yes, I am. That time.
Can I have here too, that he's established his signature health, and that it was done through his probation department.
Signature health one?
I've had an Erin, our social worker in our office, has had some issues with signature and parks are so big. If it's not the location that they're established with, sometimes getting mixed messages. I wonder if maybe that. You're receiving services through Signature Health? Or you were before you were in the jail?
Mm-hmm.
Which location did you go to?
Painesville.
Painesville? Do you know who you saw?
I'm not sure. Barbara is my caseworker.
Barbara's your caseworker? Barbara? All right, we can look at that.
I don't know what the issue is with them.
All right. Not gonna happen, sir? You don't think so?
We'll see.
Don't say that.
I don't understand what
We'll see, I got everything back up and running again.
they said they didn't
I
have
believe you 100%.
I'm working with the computer. Got a thing up for Sam. I'm not working.
What'd you do?
Change plugs around, unplug everything, reboot it.
We came back up.
Right now, yeah, we'll see. All rise. You may be seated, Mr. Culotta.
Thank you, Judge. Before you this morning are two cases, 24 CR 1389 and 24 CR 1390, both captioned State of Ohio versus Marcel T. Fialco. Judge, both cases were last before the court on March 20th of 2025. At that time, the defendant entered pleas of guilt in both cases. With respect to case 1389, the defendant pled guilty to one count of violation of a protection order, a felony of the 5th degree, in violation of ORC 2919.27A1. With respect to case 1390, the defendant entered a plea of guilty to attempted domestic violence, a felony of the 5th degree, violation of ORC 2923.02 and 2919.25. The defendant is present today in court with counsel, Ms. Smith. We are here for purposes of sentence.
Thank you.
Ms. Smith, any reason not to go forward with sentencing?
None that I'm aware of, Your Honor.
Anything you care to say at this time on behalf of your client?
Yes, Your Honor. On behalf of Mr. Fialco, we are asking for the court to impose community control sanctions in this case with an order for mental health evaluation and treatment. Mr. Fialco is 27 years old. He is single and lives with his mother, has no kids. He did graduate high school and has attended some college. The underlying force that brought Mr. Fialco before this court, and he's shown good insight into this while his case has been pending, are some of his mental health struggles. Your Honor, contrary to what was discussed in chambers, we were able to establish through the competency evaluation that was previously done for the court that Mr. Fialco is established with Signature Health. He has previous diagnoses of major depressive disorder, anxiety, schizoaffective disorder with bipolar type, schizophrenia, and acute psychoses are also possible diagnoses. He's previously been prescribed risperidone and Abilify, and does have a history of poor med compliance. He does understand that if on community control to this court, he will need to remain compliant with his medications, and we are hopeful that with both the mental health treatment and consistent medications, Mr. Fialco will not appear before this court again.
Thank you. Mr. Fialco, you have the right to address this court before your sentence, and you're here on two separate cases today, but we're doing them both together at the same time. So you have a right to speak to this court on either or both cases at this time. Is there anything you care to say on either case?
No, Your Honor.
Very well. Ms. Smith, anything else?
Not at this time, Your Honor.
Ms. Naroda for the State of Ohio.
Judge, I would note, with respect to case 1389, the victim is present and would like to address the court at the appropriate time. I don't know if that you want that to take place.
We could hear from him at this time then. Sir, you can just stand right where it is that you're seated. State your full name. Spell your last name and then say whatever you want me to know. Go ahead.
My name is Adrian Lago, L-A-G-O. This is a bigger problem than just the most recent charge. This has been ongoing for like a year and a half, maybe 2 years at this point. It's been a consistent problem. He gets out, he's released, he continues the same behavior. After being addressed by the court every time to not continue the behavior, he agrees and he's going to comply, and it happens again. And at this point, I just want to continue my life. I want to feel like I can go out in public without being in fear that I'm going to see him somewhere, or that he's going to try to attack me or try to do something again. Last time that he texted me and sent me messages, sexually explicit messages, things that it just feels like I have tried everything to move forward with my life, and he's still stuck on making sure that my life, remains in the past, and I have to keep on being reminded that it exists, and I just want to feel safe again. And I just feel like I'm sorry.
Take your
I just
time.
feel like, there's a humanity in me that I feel bad. I don't think anybody is on this earth to be bad or to do wrong things, but I just feel like as of right now, he needs to serve the maximum time, and have time to really reflect and grow as a better person. And I think the mental health things are great. I hope that he complies this time, because he's been provided that access multiple times and didn't go through with it. As far as I'm aware, I don't know the full details, but I'm pretty sure he was kicked out of the mental facilities before. And I don't know, I guess that's just really, I fear that it's going to happen again, and I fear that worse things are going to happen, and I just want to feel safe again and move on. And I hate to even have to be here today, but I wanted to make sure that it was acknowledged. And yeah.
All right. Thank you, sir. Mr. Rhoda?
Judge, as was discussed in chambers, the state is joining in the request for community control sanctions, specifically with whatever treatment or recommendations related to treatment the court deems appropriate.
Thank you. Well, this court did review the pre-sentence report and investigation, mental health evaluation, psych evaluation, I should say. I received victim impact statements from the victim in this case with the deep TPO violation as well as in the domestic violence case. I've read and considered those. I've considered the facts and circumstances of each offense, the nature of the offenses involved, and I've considered what's been said here today by Ms. Smith on behalf of her client. The defendant was afforded an opportunity to address the court. I chose not to make a statement, which is fine, but make sure that's clear on the record. What the prosecutors had to say, the recommendations, and from the victim here in case 24 CR 1389, who again not only wrote a victim impact statement but spoke here in court. All this is considered by the purposes and principles of felony sentencing set forth in 29-2911. As for the factors in 29-29-12, factors indicating the conduct is more serious. The court notes that in 1389, the relationship with the victim facilitated the offense and the victim has suffered serious psychological harm as a result of the defendant's continued violations of the protection order. No factors are present in the 1390 case. No factors are also present that make it either of the cases less serious than normal. As for recidivism factors, then it does have a history of juvenile delinquency adjudications as well as criminal convictions. Why did you report that you don't have any juvenile delinquency adjudications? You've been in juvenile court, you were there at least 3 separate cases, and then you were certainly there more because you violated your probation multiple times.
I forgot that I had any juvenile convictions.
I'm sorry?
I forgot that I had any juvenile convictions.
How old are you?
I'm 27. The only one I remember is one that I threw a rock and it hit a windshield and I got community control.
Well, why did you say that? Why didn't you mention that?
I don't know, Your Honor.
You had 3 convictions in juvenile court. Adjudications, I should say, I guess. But the probation, 3 probation violations when you were on probation there. So you were there multiple times.
I was on probation in juvenile.
Well, you probably didn't realize it because you violated it repeatedly, but yeah. For skipping school, not going to school.
I wasn't aware.
You went to court 4 times for it. You got put on probation and you violated probation 3 times. You went to court 3 separate times for probation violations. Boy, this is going to be... If I put you on probation today, are you going to know it?
Yeah, Your Honor.
Well, then once you became an adult, you committed offenses. Then I committed this offense while he was on probation, Painesville Municipal Court. You know you're on probation, you were on probation, Painesville Municipal Court?
Currently?
Well, you were earlier, like last year.
Yeah.
I don't know if you still are or not. Are you still, or did they end it?
They ended it.
Because you didn't comply and they just gave you jail time and you finished?
Yeah.
So he's on probation when he committed this offense. He's got a history of criminal convictions. He's got history of failing to comply with previously imposed sanctions of the court. Every time you've been on probation, you violate. And one case involves not complying with previously imposed sanctions in the court. When you're in the jail, you have at least 4 disciplinary violations that you've been disciplined for not following the rules in the jail. No factors indicate less likely to commit crime in the future. Again, on 29-29-13B1, the defendant committed the offense while on probation, which is a factor that overrides any presumption for probation and permits the court to impose a prison sentence. the history of probation violations here and the history of just not following rules and doing what you're told to do, the court can easily find prisons consistent with the purposes and principles of sentencing. I need to determine, before I can put you on probation, whether you're amenable to community control sanctions, which means whether you are able, willing to follow the rules, do what's told of you, comply with the conditions of probation. And I look at the history here and the nature of this offense, at least in the 1390 case, and I say, you're not able to do that. You tell me why it's going to be completely different from every other case you've had when you haven't followed any rules.
I've had time to think it over in jail, and I will be able to follow the community control. The other offenses, the other violations were minor things that I didn't realize were going to be violations. Like one
That's
of
a
them.
concern too, because we're going to make sure you're clear then, because I'm not going to, I just wanted to say hi. That's not an excuse. What about not complying with the rules in jail?
They put me on meds that they made me temporarily psychosis, and then I destroyed a mat on the meds, and they took me off the meds.
I guess, what didn't you know you weren't supposed to do when you were on probation to Painesville? You were in jail. They filed a motion on your behalf to get you out of jail early so you can go into a treatment program to complete that program.
Mm-hmm.
You didn't complete the program.
I forgot to.
What didn't you know? You didn't realize you had to complete the program?
I forgot to charge the ankle monitor, and then they took me back to jail.
So you didn't know you were supposed to do that?
I didn't realize it died.
Sorry?
I didn't realize it died.
Well, then you didn't pay attention when it was put on you, because they tell you how to do everything.
The guy that put it on me didn't explain everything.
And this is going to be a struggle, I anticipate. Why don't you follow the orders for these protection orders that are imposed when you're not supposed to have contact with the person?
Your Honor, I was still in love with him. I'm no longer in love with him.
I don't care if you were still with them. What did you say?
I was in love with him.
Okay. You were told not to have any contact with him.
Yeah, I understand that. I'm not going to have any more contact with him, Your Honor.
Well, everything you've had in the past has been misdemeanor charges. You now have felonies on your record because of this. You've never been on probation over here. If you couldn't handle it over there, what you had over in Painesville Municipal Court is going to be nothing compared to your probation here. You understand that?
Yes, Your Honor.
I'm going to give you one chance at completing the probation over here, but one chance.
Yes, thank you, Your Honor.
If you don't do it, you're going to prison for the maximum sentence. I can assure you of that. And I want to make sure we're clear on something. I'm going to put the conditions on here in a second, but you're not to have any contact with the victim here. You understand that?
Yes, Your Honor.
That means you can't personally see him, you can't call him on the phone, you can't text him, you can't email him, you can't write him letters, you can't have anyone else reach out to him on your behalf, you can't go on social media sites and like comments that he makes or posts that he makes. And I don't care if it's something as nice as could be. You'd be calling him, reaching out to him for his birthday just to say happy birthday, just to say hi. You can call him and say happy birthday and you're going to prison for the maximum time. You understand that?
Yes, Your Honor. I understand that it's not helpful to him.
Well, certainly I care whether it's helpful to him, but I also want to make sure it's clear that you're being ordered not to do it.
Yes,
so even if it was helpful to him, you can't do it.
I understand, Your Honor.
So what's going to happen if you reach out to him and say hi?
I'll get maximum time.
If we go on one of his Instagram or whatever pages he's on and just like a comment he makes, what's going to happen?
Maximum time.
What if one of your friends do it? Hey, if you see him, tell him I said hi. What's going to happen?
Same thing.
So we're not going to come back here at any future time and you say, I didn't realize that was a violation. I didn't know that.
No, Your Honor.
While I find at this time the defendants have not ultimately available community control sanctions, I'm going to put them on community control sanctions for a period of 2 years. In case 24 CR 1389, that's the protection order case, I'm going to order that he serve 180 days in jail. He has credit for 151. In case 24 CR 1390, I'm going to put on community control sanctions for 2 years. I'm going to order they serve 152 days in jail with credit for 152. So I've got 29 more days, all under the 1390 case. Further conditions for both cases: not to use any drugs or alcohol. That means no marijuana. It doesn't matter if you have a marijuana card. Just because you have a marijuana card doesn't mean it's okay to smoke marijuana or use gummies or any type of marijuana. You can't do it. You understand that?
That's right.
You must submit random urine screens. They have to be negative. A positive screen is a violation. If you screw around with the urine sample, bring in fake urine, someone else's urine, that's maximum sentence too. You understand that?
That's right.
I want you to obtain and maintain full-time employment. I want you to focus on your mental health. I want you to get a full psychiatric evaluation, follow all the recommendations that were made, including any recommendations for medication, take all medications as prescribed. I want you to continue with your mental health counseling, follow all the recommendations. Are you attending mental health counseling, or you weren't?
No, Your Honor.
All right, well, then we'll get a mental health evaluation and follow all recommendations for counseling for mental health. I want you to complete the Decision Points program. It's a program with our probation department that helps you make good decisions with your decision making. You also need to obtain anger management classes, learn how to better deal with those situations that put you over the edge. You'd have one doctor, one dentist that can prescribe you medication, one pharmacy where you get prescriptions filled. Excuse me, make sure probation knows who those doctors are and where those pharmacies are. If you have a specialist, that's fine too. They need to know who they are and you need to sign any releases so they can contact any of these doctors if necessary. Pay court costs and supervision fees. You'd have no contact with Adrian Lago. You understand that?
Yes, Your Honor.
We already went over this, but you understand what that means?
Yes.
None, in any manner whatsoever. Again, I don't care if it's for the nicest reason in the world. You're going to prison. Understand?
Yes.
Kaylee, is there anything else I'd consider here?
No, Your Honor, nothing further.
Where are you going to be living? With your mom?
Yes, Your Honor.
Where's your brother live? The one that was involved with this domestic violence.
He should be living by himself by now.
He visits your mother, right?
Yeah.
What's going to happen when you're together?
Nothing.
Shafiat, we understand all the conditions of your community control sanctions.
Yes, Your Honor.
Any questions for me?
No, Your Honor.
I need to advise you if you fail to comply with any of the conditions, any of the rules of probation, you commit a new crime while you're on probation, or if you leave Ohio without permission from the court, a motion to terminate your community control sanctions will be filed. If it's found that you violated, I could extend your probation up to 5 years, impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did that, in case 24 CR 1389, it'd be 12 months in prison. In case 24 CR 1390, it would be 12 months in prison. Those two cases would be consecutive to each other, so for an overall prison term of 2 years in prison. You understand that?
Yes, Your Honor.
All right, Mr. Fialko, you need to focus on the mental health here. You need to go through the evaluations, you need to follow their recommendations. Take the medications that are prescribed to you. Sounds like you started taking something over there already.
Yeah,
How's that helping you?
it's good.
Well, then keep doing it. That's the point. That's the purpose of it. That's the purpose of all of this. Try to help you figure out a way that you feel better. You're not doing this stuff anymore. Understand that?
Yes, Your Honor.
All right. Ms. Smith, anything else?
At this time, Your Honor.
Ms. Miller?
Nothing further, Judge.
All right, thank you.
All rise.
Thank you, Your Honor. We're present in State of Ohio versus Giovanni Gibson, case number 24 CR 1462. The defendant is in court, represented by counsel Jim Matthews. We are here today for purposes of sentencing. When we were last here on March 20th of this year, the defendant pled guilty to count 1, having weapons while under disability, a felony of the 3rd degree with the attached forfeiture specification. The court referred the defendant for a pre-sentence report. That report has been completed and the state's prepared to proceed with sentencing.
Right here, 1 second. And you gotta make sure you open the right file.
Open Robinson?
You open case from 20. All right, Mr. Matthews, any reason not to go forward with sentencing?
No, Your Honor.
Anything you'd like to say on behalf of your client?
Yes, thank you. Your Honor, Mr. Gibson is requesting community control in this case. He does understand that he was unsuccessful on community control in this court approximately 4 years ago. However, in the pre-sentence report, he does indicate that he is now prepared to be on community control, whereas he really doesn't think that in the past that he was. He is prepared to adhere to whatever conditions the court would impose. It is our understanding that the probation department is recommending that he go to NeoCap. If that is what the court decides, Your Honor, he has indicated that he will enter into and successfully complete that program. And there is a member of his family that does wish to address the court. Thank you.
They do wish to address the court?
A member of his family.
Okay. Well, whoever it is that would like to address the court, you can stand right where you are, or you can sit, whatever you're comfortable doing. State your full name so it's clear for the court reporter, and then say whatever you'd like me to know.
My name is Jacqueline Hall Gibson, Giovanni's mother.
What's the last name?
Hall Gibson, Hall-Gibson.
Gotcha.
On behalf, this is his father here, his sister, and my son-in-law, on behalf of Giovanni, I would just like to say that prior to the incident, his father was subjected to a stroke June 12, 2024, which then took him, he was working at PCC. Gino became the primary caretaker so that I was able to continue to work physically because he's disabled on the right side. I would just like to ask if we could have mercy on the court to give some type of probation or with any type of extremity home monitoring for him to be able to do that so that I'm able to continue to take care of him.
Thank you. Mr. Gibson, you have the right to address the court before you're sentenced. You can say anything you want. Is there anything you want to say?
No, sir.
No? Well, why is it going to be different this time? You were on probation with me last time. I gave you multiple chances. You got kicked out of programs. Why is it different now?
Because I'm not young-minded and I got a lot to lose this time. Like,
You
my father...
What's the difference? You had a lot to lose last time.
I understand that, but my father wasn't down and I was the only one that needed to help my family back then. And this time I'm not trying to finesse my way through no system or nothing. I'm just trying to get off probation and prove to myself and to you that I can complete probation.
What I'm looking at here is your pre-sentence report from last time that was accidentally pulled up, but I'm glad it was. Because you said similar stuff. I guess I don't know how. You'd have to prove it to me, because you said the same stuff last time. You said you're not pretending this time, but last time you were talking about the same thing.
I was more young-minded and just didn't really care about being on probation. I want to be on probation to prove to myself that I can finish it.
So what do you do every day? Even works. I don't know. There's no work history here. So you've never worked. What do you do?
Jobs, babysitting and stuff like that. Yard work.
How old are you?
31.
31.
Yeah.
And you've never had a job?
I had a job that I just didn't have it for a long time. I worked in a factory and I did roofing.
When was that?
Years prior to me coming to prison.
So how do you pay for your daily marijuana? Where's the money come from that you're buying marijuana? You're able to smoke marijuana every day since you've been 18 years old. So for whatever, 13 years.
Sometimes it's not paid for. Sometimes it's just going around people that smoke with me. Sometimes I buy it myself.
How do you support yourself?
Day by day, I don't really support myself.
Who supports you?
My parents.
Probably time you start taking care of that yourself, no?
Yeah.
You got a child too that you're what $17,000 behind in arrears?
Mm-hmm.
If you get put on probation, you're going to have to obtain a full-time job, verifiable employment, work full-time. You're able to do that?
Yes.
Is there anything else you'd like to say?
No, sir.
Ms. Alessi for the state.
Thank you, Your Honor. The state is asking for prison in this case. The defendant does have a criminal history, although it is not lengthy. It does include a prior felony offense, possession of cocaine, a felony of the 5th degree, and an M1 OVI, which he was granted community control for and placed on to this court. While on community control, he had 2 separate violations. The first violation was for a positive drug screen, at which time the court extended the community control. He was supposed to go to Concord Pines, and he was negatively discharged from Concord Pines, which resulted in the second violation, and this court ultimately did send him to prison in that case. The defendant has had prior treatment pertaining at least to drug and alcohol abuse. He's gone to Lake Geauga twice, he's done jail treatment program twice, and then as I stated, he started the program at Concord Pines, but was unsuccessfully terminated for threatening other members that were a part of that program. So the state does not think he would be amenable to any community control sanctions. In addition, just the facts and circumstances surrounding this case, the defendant wasn't a passenger in a vehicle being driven by a co-defendant in this case. That co-defendant had on him an F1 amount of cocaine as well as a firearm himself. So the state does think prison would be appropriate. The defendant has 125 days of credit. Thank you.
This court has reviewed the pre-sentence report. Sorry. Investigation. Should have considered the facts and circumstances of the offense involved. the nature of the offense involved. I've considered what's been said here in court today by the defendant, his lawyer, the prosecutor, his mother spoke, taking all this into consideration. All this is considered in light of the purposes and principles of felony sentencing set forth in 2911. For the factors in 2912. Factors indicating the conduct is more or less serious. I will note Mr. Gibson's not charged with any drug violations, but there was a lot of drugs found in the vehicle in which Mr. Gibson was in with this firearm, and just that whether I'm not saying he knew about it, he's not charged with it, but just that those circumstances make possessing that firearm much more dangerous in those circumstances. Nothing makes it less serious. As for recidivism factors, the court finds the defendant does have a history of criminal convictions, has previously served a prison term before. He's not responded favorably in the past to previously imposed sanctions. He's been on probation of this court before. He violated a couple times before he was ultimately terminated and sent to prison. Kicked out of a treatment program. The court will note that he has been very cooperative with the probation department going through this process. This is a felony in the third degree. No presumptions either way in regards to probation or prison. It's struggling because I can't disagree with anything the prosecutor said here. The biggest being that you've been on probation in me before the past, and it wasn't that long ago. And you have multiple violations. So how do I get past that this is going to be different this time? You see, you're older, but I don't know what that means. You don't work at all. I don't know what you do every day. But I'll give you one shot, Mr. Gibson, to prove that you're sincere here, and this isn't just you pretending again, like you said you did last time. I find that you're amenable to an available community control sanction. I'm going to put you on community control sanctions for a period of 2 years. I'm going to order that you serve 180 days in jail. You have credit for 125. I'm going to order that you also enter and successfully complete the program at NeoCap. As soon as a bed's available, you can be released from the jail, and the balance of that 180 days will be vacated, so you won't have to serve the whole time. It just gives enough cushion to get you into the program. So once you get in, any balance of jail time is suspended or vacated. You complete that program, follow all their aftercare recommendations. Upon completion of NeoCap, I'm going to order at this time, you're probably not going to have to do this, but I put it in place for all NeoCap. Return to the jail for 30 days for the Transitional Day Reporting Program. That's a program that helps people make the transition from being locked up and on their own to being, from being locked up to transitioning to being on their own. Some people don't have anywhere to go when they get let out. But if you have a place to live, you work on getting your employment set up. If all that's set, then you won't have to do those 30 days, and they'll vacate those. But I put it in place for everybody because it's a good program that helps people make the transition for those that need it. So 30 days TDR. The other conditions, you're not to use any drugs or alcohol. That includes no marijuana. You submit random urine screens. They have to be negative. A positive screen's a violation. Follow all aftercare recommendations from NeoCap. So I'm not going to order any specific AA meetings or anything like that. But if NeoCap does it, and that's part of the recommendations, then you'll have to do it. You are to obtain full-time employment. So you need to get the job as soon as you're done with NeoCap. It's going to be verifiable full-time employment. not to possess any firearms, not to have contact with Jerome Jackson, pay court costs and supervision fees. Basically, once you get on NeoCap, you're just not to use any drugs and to work, which is what everybody should be doing. Is Henley anything else I'm missing here? I feel like I'm missing something, but I guess. Oh, hang on. You don't have your GED? You ever tried to get it?
When I was in prison, but I got released early.
I'm going to order that you make a reasonable effort at obtaining it.
Okay.
All right, Ms. Henley, anything else?
No, Your Honor, thank you.
So you understand all the conditions, Mr. Gibson, of your probation?
What'd you say?
You understand the conditions of your
Yes.
probation?
Yes, sir.
Any questions for me?
No.
I need to advise you, if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from the court, or if you commit a new crime while you're on probation, a motion to terminate your community control will be filed. If it's found that you violated, I could extend your probation up to 5 years. I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. And if I did that, it'd be 36 months in prison, so that's what's hanging over your head. You understand that?
Yes.
All right, I will dismiss the balance of the indictment at this time, and I'll order the forfeiture of the instrumentalities and contraband set forth in the spec. Ms. Alessi, anything else?
No, Your Honor, thank you.
Mr. Matthews?
No, Your Honor, thank you.
Thank you.
All rise.
Here today in the State of Ohio versus Daniel Manning, case 24-CR-1467. The defendant is present, represented by counsel David Urbancek. We're present for the purposes of a sentencing hearing. A pre-sentence report and drug and alcohol evaluation have been completed, and the state and defense counsel have had an opportunity to review those evaluations. There is no joint recommendation as to sentence, and the defendant has 29 days credit.
Thank you. Mr. Bancek, any reason not to go forward with sentencing?
No, Your Honor.
Is there anything you care to say at this time on behalf of your client?
Yes, Your Honor. David Urbancek on behalf of defendant Daniel Manning. It is my belief that the crime in this case was committed as a result of Mr. Manning's drug dependence issues, and those were also identified in his reporting, which was done while he's been in the jail for the past 3 weeks. He believes that with sufficient treatment, he'll be able to re-enter society as a productive member and return to work. Thank you.
Mr. Manning, you have the right to address this court before you are sentenced. You can say anything you like. Is there anything you want to say at this time?
Yes, Your Honor.
Go ahead.
I would like to say that I take full accountability for all my actions. I'm sorry for my actions, and it's out of character, and I just want to get the help that I can get so I can, be a better person.
Anything else you care to say?
No,
you don't
Your
have to.
Honor.
I just want to make sure you said everything you wanted to. You good?
Yes, Your Honor.
Excuse me. Mr. Bancek, anything else on behalf of the defendant?
If I may, Your Honor, the prosecution made a recommendation that there be restitution in this case.
Yes.
I'd like to address that. The defendant and also the other suspect in this case, Michael Tate, have consistently denied that there was any cash in the box that they took, and that is with the full admission of guilt and accountability of the theft. They still deny that there was any cash in the box. So if Your Honor would take that into account when considering restitution.
Okay. Ms. Tuttle for the State of Ohio.
Thank you, Your Honor. This is a difficult case for the state. Certainly a prison sentence is consistent with the purposes and principles of felony sentencing, and the state has offered a major benefit to the defendant by reducing the charge to a felony 3. The defendant has had previous opportunities at treatment and previous breaks and reductions. He also violated the conditions of his bond by using illegal drugs. However, it's also clear to the state that Mr. Manning does have a severe and substantial drug problem and will likely be back in the same position if he doesn't address that. If the court determined that a community control sanction was appropriate in this matter, we would ask that the defendant be given a lengthy treatment program so that we give him the best possible chance at success. If community control were to be imposed, the state would ask that the defendant be ordered to participate in the jail treatment program, NeoCap, inpatient residential treatment, and sober living. 28 days simply isn't a long enough treatment program. The jail treatment program alone isn't long enough either for somebody that has a drug problem like Mr. Manning does. Further, the state is requesting restitution to the victim, Julie Thies, that's spelled Theiss, in the amount of $3,057.79 for out-of-pocket loss. Ms. Thies made an insurance claim through Allstate for the damage done to her bedroom furniture, as well as for the cash box that was stolen and the money that was stolen inside. Ms. Thies reported that $2,800 was stolen from that cash box. I know that the defendant does not agree with that amount of money, but regardless, the defendant has admitted that he took something of value, that he took something he didn't have the money to pay for from Ms. Thies' home, and therefore there should be restitution ordered. Her remaining out-of-pocket loss after insurance is that $3,057.79 amount, so we would request that in restitution. Thank you.
Thank So let me ask a question, Ms. Tuttle, on the facts. My understanding, my recollection from the plea was that a drug transaction had been set for some other location with the victim in this case.
So there's...
So, hang on, let me finish. So that would take her out of the house, and that's the same time that they went into the house. Am I correct in that?
So Mr. Manning did provide text messages to the police arranging some sort of meeting with who he purported to be Miss Thies on Babbitt Road at the same time that he entered the apartment.
Thank you. This court has reviewed the pre-sentence report and investigation. Drug and alcohol evaluation that was completed. I've considered the facts and circumstances of the offense involved, the nature of the offense. I've considered what's been said here in court by the defendant himself, his lawyer, the prosecutor. All this is considered by the court in light of the purposes and principles of felony sentencing, which are set forth in 2911 of the revised code. As for the factors, in 2912, indicating the conduct is more or less serious, the court finds that when the defendant committed this offense, there was a person in the home, not just a person, but a 14-year-old child was in the home when he broke into the home with his co-defendant and committed this offense. That makes it much more serious than what normally constitutes the commission of this offense. It was also well, planned out. He set it up to lure her out, to lure the mother out of the house, the adult out of the house, so that she wouldn't be there when they went in there. But again, the 14-year-old was there. His relationship, whatever the nature of it is, drug dealer relationship, facilitated the offense. There's no factors indicating it's less serious. As for recidivism factors, the court finds that the defendant does have a history of criminal convictions. Conviction back in he's got some incident that occurred in the Army with drugs. 2012 then, he had a drug case with Nashville County and a completed intervention of conviction. That case was dismissed. Back in 19, he had a charge that was reduced to a misdemeanor, attempted charge. He then had an attempted breaking and entering. So he's been getting these breaks. They kept reducing these felony conduct to a misdemeanor. That was just in July of 23, and then this happened a year later. Court defendant violated conditions of his bond, not just in using drugs while he was on bond, but also trying to defraud this court. You were supposed to go right to the probation department when you left here last time, and you didn't do that. Instead, you were gone for about an hour and a half, and all of a sudden you show up with some BS story about some emergency that you had to attend to, and you pick up your daughter from school, and she's sitting out in the car, using your daughter for your story to help you lie. When they go out there, your daughter's not in the car. Meanwhile, you were really trying to go to get fake urine to defraud the court and defraud the probation department. It's not a good way to start your audition to determine whether you're appropriate for probation. And the first time you have to report to the probation department, you're attempting to defraud them, bringing in fake urine. or trying to bring in fake urine. Couldn't even go over there right away, lying to them about why you weren't there. There is a drug problem that relates to the commission of this offense, and the defendant doesn't deny it's a drug problem. I don't know if he understands and recognizes the extent of the drug problem. I think he believes that his 29 days that he's spent in jail has sobered him up, and he's good to go. He's sober now, and he's good to go. But here's what you've been doing with your drug issue for the last, let's see, the last 5 years, you drink a fifth of booze every other day, every couple of days. Add to that, since you've been 18 years old, so for 7 years, you use at least a gram of methamphetamine every day for the last 7 years. Add to the booze and the meth, for the last 2 years, every day, you do Percocet 30s, which is fentanyl and heroin. So every day for the last 2 years, you do basically a fifth of booze every other day, gram of methamphetamine, Percocet 30s. For the last 5 years, you've been doing the booze and the meth. That's a significant, significant problem that needs to be addressed. And 29 days sitting in the county jail doesn't solve that problem. If you're going to be on probation, there needs to be some significant treatment to address it. There's no factors indicating recidivism is less likely. This is a felony of third degree. There's no presumption for probation or community control. Excuse me, there's no presumption for community control or prison. The court can impose either without making any special findings. And with the nature of the offense and the conduct involved, this is certainly an offense in which prison is appropriate. Committed a burglary in the middle of the night with a 14-year-old child in the house. Quite frankly, it's almost a no-brainer for prison for me. But I will give you one chance, Mr. Manning. That's one chance, and you're going to get every resource we have available to help you get better. I'm not going to save anything back so that if you screw up or mess up, we have something left to do. You're going to get all the opportunity you have at the very beginning. And hopefully it works when you're sincere with what you say. And you do want to get better. It appears you did do well for a while. I'll find you're amenable to an available community control sanction. I'm going to order that you be placed on community control sanctions for a period of 30 months. I'm going to order that you serve 75 days in Lake County Jail. You have credit for 29 you've already served. In order that you immediately enter and successfully complete the jail treatment program. Upon completion of the jail treatment program, or to enter, successfully complete the program at NeoCap. Upon completing NeoCap, I'm going to order at this point, you're not going to have to do this most likely, but it's going to be part of the order to help make the transition. 30 days in the Transitional Day Reporting Program. And then I'm going to order that after NeoCap you enter, complete the residential program at either Lake House or Concord Pines. Follow all the aftercare recommendations from these places. You then to reside in sober living for at minimum 6 months. You can stay there for as long as you want. Other conditions, you're not to use any drugs or alcohol. You must submit random urine screens. They have to be negative. Positive screen will be a violation. You're to attend 3 AA meetings a week and have a sponsor. Once you get done with all this, and hopefully you're doing well, you're to obtain and maintain full-time employment. You're only to have one doctor and one dentist that can prescribe you medication, one pharmacy where you get them filled. Probation needs to know who those doctors are. You need to sign releases so they can contact them if needed. Prepare court costs and supervision fees. I'll have you obtain at some point when this will be able to be addressed while you're doing your treatment, but a mental health evaluation and follow whatever recommendations may be made for mental health counseling or treatment. I'm going to order restitution to the victim in the amount of $3,057.79. I'm certainly not. You broke into her house in the middle of the night, the intent of stealing her safe and the contents of the safe, and if you're expecting me to believe you over her, what was in the safe, I'm not going to do that. The insurance claim was made, part of it was paid off, and I'm going to find restitution in the amount of $3,057.79. Newman, anything else I should be considering here?
No, Your Honor. Thank you.
Mr. Manning, understand all the conditions of your probation?
Yes, Your Honor.
Any questions for me?
No, Your Honor.
I need to advise you, if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from this court, if you commit another crime while you're on probation, a motion to terminate your community control sanctions will be filed. If it's found that you violated, I could extend your probation up to 5 years. I can impose more restrictive sanctions against you, including an order that you serve time in jail, or I could terminate your probation and send you to prison. And if I did that, it would be 36 months in prison. So that is what is hanging over your head. You understand that?
Yes, Your Honor.
All right. Ms. Tuttle, anything else for the record?
No, Your Honor, thank you.
Mr. Vincent?
No, Your Honor.
All right, good luck.
All right.
second, please. Thank you.
Yes, sir.
Now, we are present in two cases here today. The first is, well, both captioned State of Ohio versus Craig Davis. The first is 13 CR 519. Second is 18 CR 1158. The defendant has filed an application for sealing of the record in each of these cases. Upon receipt of these motions, the court referred the matter to the probation department so they could prepare an investigation report for the court to be able to review. That has been completed, and we are scheduled here at this time for a hearing on these requests and the application. The defendant is here in court. He's with his counsel, Mr. D'Angelo Little. Mr. Little, would you care to be heard on your request, your applications?
Yes, good afternoon, Your Honor. May I please the court? As the court indicated, I did file 2 applications for sealing of the records for my client, Mr. Craig Davis. At the time I filed those requests, it was my understanding that Mr. Davis would go ahead and satisfy his court costs and supervision fees with this court prior to the hearing date being set. To date, my client has failed to do so, Your Honor. He intended to pay those obligations, but he ran into some financial difficulties that kind of restricted his ability to make those payments, Your Honor. I did speak with members of the probation department. Obviously, they oppose the applications, rightfully so, because my client has not paid the necessary fees and costs, Your Honor. I would ask this court for one final continuance so that my client can go ahead and satisfy those obligations. If not, Your Honor, we would withdraw the motion and I will just reapply the time that those are satisfied, Your Honor. Thank you.
What's the state's position? I know the position in terms of the cost being outstanding. I guess for argument's sake, if the costs were paid, what's the state's position on this?
The state would have no opposition if he qualified, and we believe it's simply the payment.
Be realistic.
Let's think about rent is coming up. About 30 days just to get this out. I just have rent to get out the way, car payment.
I'm fine with that. I give you longer too. So be real. I don't want to come back here and say something. I'd rather give you
about 45 days.
45 days?
Yeah, 45 days. 45.
What are you doing now?
I work at Buyers Products.
Buyers?
Yeah, Buyers
Is
Products.
that over on Tyler?
Yes.
Okay. What do you do there?
I am a forklift operator / like runner. So I've been there for a minute now.
What's a minute mean?
About a year. Okay, sorry. about a year. So just car have just went down, so I just got a new car. That's also where my money.
How often do you work? Full time?
Yeah, full time. Yes.
What's that? 40 hours? Or
40 hours. We were just in the busy season is in the winter, so now we're just slowing down a little bit. So about 40 hours a week, full time.
What do you do?
Well. I'm a forklift operator there as well. Also have a DJ business that I run as well. So.
But I meant at the Buyers. You're a forklift operator?
Yeah, forklift operator.
But
Yes,
then you do
correct.
side work also then?
Yes. So now I'm just getting.
You get benefits and all that at Buyers?
Correct. Yes.
Full benefits?
Yes.
So you got a good job there.
Yes, I'm blessed blessed. For sure.
Okay. Let me just look at something here real quick. So since my case here, there's been nothing, huh?
No. I'm leaving Lake County behind me. Believe. No.
All right, well, I'll reschedule this hearing. I don't think it's really necessary to even have a hearing. scheduled for a specific date. If it's paid off before that, no, we don't need to do this. I'll grant your motion. If it's not, I'd probably suggest withdrawing it then.
Right,
I mean, there's no reason to come back here.
right, I understand.
But if I don't hear from anybody, if you don't pay it and don't get a withdrawal, then you're gonna have to come back here just to be told no.
Correct.
So that's a waste of time. So we'll do it this way. What's today's date? April 14th. I will set this hearing for June 16th. That's 60 days, 2 months. When it's paid, you're gonna pay probation department. They'll notify me.
Okay.
If it is, I'll do an entry granting it, and you'll get that, and you'll know that you don't have to come back.
Okay.
If it's not paid, then I will assume that I'll get a motion, or not even a motion, just a withdrawal of the motions before June 16th. If neither of them happens, then I guess I'll see you June 16th, but then you're going to be wasting your time coming here for nothing. But so either pay it by then, withdraw it by then, and then as long as that's done, then the 16th will be off. Okay?
Sounds good, Your Honor.
All right.
Thank you so much.
Good luck to you. Continue doing well.
Thank you.
All rise.
Your Honor. We are here on the matter of the State of Ohio versus Marco Woods, case number 25 CR 000136. The defendant is present in open court with their defense attorney, Rachel Smith. We are set today for a sentencing hearing. Parties were last here on March 17th when the defendant pled guilty to count 1 of the indictment, possession of cocaine, felony of the 5th degree. Since then, a pre-sentence report and drug and alcohol evaluation has been completed. After sentencing, the state would move to dismiss the remaining count on the indictment, and the defendant has 82 days of jail time credit. Thank you.
So it's 82?
82, that's correct, Your Honor.
Thank you. Ms. Smith, any reason not to go forward with sentencing?
None that I'm aware of, Your Honor.
Anything you'd like to say at this time on behalf of your client?
Yes, Your Honor. Mr. Woods is here having pled guilty to a felony of the 5th degree possession count. He's 46 years old, has obtained his GED. He's single and has 3 kids. As outlined by the state, he has 82 days of jail time credit. Your Honor, we are asking for the court to impose a minimum prison term here. Mr. Woods does have the good insight into himself to know that he's not amenable to probation. He does have an extensive criminal history, as well as an extensive history of drug use. He has accepted responsibility for his conduct, and throughout the incident, as well as throughout dependency of this matter, he was cooperative with law enforcement. He was cooperative with probation, has been cooperative with myself, and so he is asking the court to impose a 6-month prison term in this case.
Thank you. Mr. Woods, you have the right to address the court before your sentence. You can say anything you'd like. Is there anything you want to say?
Yes, Your Honor. I just want to say that I take full responsibility of my actions. And I got people that out there depending on me. I got 3 kids, I got family, and I'm just ready to move on with my life, Your Honor. That's all.
Thank you. Ms. Smith, anything else?
Nothing additional, Your Honor.
On behalf of the state of Ohio, no?
Thank you, Your Honor. The defendant has pled guilty or been found guilty to approximately 16 felonies by our count. He has been to prison on 12 separate occasions, has 6 different prison numbers. He's had treatment at least 3 times, though he admits right now that he has a PCP problem. And it's my understanding that he told Lake Geauga that he would rather go to prison instead of drug treatment. So it's the state's position that the presumption of community control has been overcome and that the defendant should serve a prison sentence. Thank you.
Thank you. This court did consider the pre-sentence report investigation that was prepared in this matter, as well as a drug and alcohol evaluation. I've considered the facts and circumstances of the offense, the nature of the offense. I've also considered everything said here today. All this is considered by the court in light of the purposes and principles of felony sentencing set forth in 29-29-11. For the factors in 29-29-12, I will incorporate all. I find as factors indicating it's more serious. None of the factors are present indicating it's more or less serious. As for recidivism factors, the court finds that the defendant was on bond. He'd actually absconded from GPS supervision at the time from Cuyahoga County at the time he committed this offense. He's got a very extensive criminal history. He's served multiple prison terms before in the past. Appears to be a drug problem related to the offense. He doesn't want to get treatment for that at this point. Nothing indicates it's less serious. For 29-29-13B1, the court finds again the defendant previously served a prison term which overrides the presumption for community control. Court finds the defendant that prison is consistent with the purposes and principles of sentencing. The defendant is not amenable to any available community control sanctions. Therefore, it will be the sentence of this court that the defendant serve a term in prison of 8 months. He has credit for 82 days he's already served. I need to advise you upon your release from prison, you could be placed on post-release control in this case for up to 2 years. If you are and you're violating those conditions, the parole authority can send you back to prison as punishment for violating their rules for another 4 months, the maximum being 50% of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. I will dismiss count 2 in the indictment as agreed upon. I'm going to order the forfeiture of the contraband and instrumentality set forth in the specification. Any bond posted is hereby released. Is there anything else for the record at this time, Ms. Smith?
Not on behalf of Mr. Woods.
Mr. No?
No, Your Honor.
Thank you.
All rise.